Carrie is our first speaker this morning. She's the president of Judicial Crisis Network. And I've had the privilege of hearing her speak a couple of times at some of our leadership meetings. Her dedication to ensuring that our judicial system will be constitutionally sound gives me hope for our country. It's a pleasure and an honor to have her here today with us this morning, and I know her presentation will set the stage for the rest of the day's presentations. After she's done with her presentation, we will have a question and answer time with her. So if you're viewing virtually, we want to encourage you to put your questions in the chat feature, and I will get those on my phone or my iPad so that we can pass them along, and we'll have a wonderful conversation afterwards. So Carrie, come on up. Thank you, my dear.
Thanks so much.
Blessings. And happy birthday.
Thank you.
Yes, today, it's today?
That is right. That's part of my excuse here. I came downstairs thinking I was just gonna get ready and run out the door, and my kids had surprised me with a whole tea and all these little posters they made. My youngest, my husband is Colombian, so he speaks Spanish to them. She had this adorable Spanglish sign that said, "Mommy, yo hope to have un happy birthday, te quiero more than bacon." So, I mean, what can be better than bacon?
Totally possible. And her birthday's tomorrow?
No, it's my 12-year-old girl who's turning 12 tomorrow. So I've got 6. So there's a lot of birthdays, and it's busy. So yeah, she was born on the anniversary of Roe versus Wade, and I have to say, I can just start even from there. When she was born, I sort of thought it's a strange birth date for someone who's been working a long time in the pro-life movement. But I never expected, I don't know if I even expected in her lifetime that we would necessarily see the end of Roe. And it's amazing to me to think, here we are standing just before she turned 12, and we have actually finally accomplished this goal that I know so many in this room have been working for even longer than I have. I remember going to the March for Life in college. I remember going when my first child was born, a month old, carrying her in my arms. I remember watching it from the Supreme Court. And boy, that was amazing. You're used to these protests that are, at the time, I mean, now it's become almost a little mini industry of having protests in front of the Supreme Court. But at the time, it would be unusual to have more than even 20 people there. It's like, oh wow, there's a protest today. This is exciting. There were only 2 protests that stood out. One of them, and I think it was Students for Life who did this, was there were almost every day that I can remember walking up to that court, there was someone standing on those steps with the red tape over the mouth that said life on that. Do you remember those? Have you seen pictures of them? It was really striking as someone working in that building, and I always felt like I wanted to, say something and be like, yes, thank you, but as a officer of the court at the time, I couldn't really speak out, but that quiet and silent presence was so powerful to me, and I think that illustrates a lot of what this movement is about, of people who are just, when they're not being seen and not being heard, going and standing and praying in front of the clinic, going and volunteering at the crisis pregnancy. What seems to be unseen and has huge meaning. And that was one of the 2 protests that was different, that stood out. The other one was the March for Life, on the complete opposite end of the scale. Again, we're used to seeing these smallish, groups in front of the court from time to time. And the March for Life, and that year, the offices have moved around. That year, Justice Thomas's office, because of construction, was in the front side of the building. So I remember going down to the main office and just looking out the window, and it was as if you're standing on Mont Saint-Michel or some mountain at the ocean, and there's waves of people crashing against the building. But at the same time, in a completely peaceful and prayerful way. So it was all day, just watching countless people go by, and that was incredibly powerful as well. That it was a peaceful group, which unfortunately, increasingly, they no longer are. It certainly wasn't what the groups were like after the Dobbs leak and moving on to the actual decision. But it was also an enormous number of people. And I think that spoke to how wide and how deep this movement really is. So how did we get here? How could we get from a situation where we have a Supreme Court that short circuits this public debate on such a key issue to 50 years of marching, walking, praying, working, and actually have it happen. And on the cusp of the 50-year anniversary, I think a lot of the key of how this change happened is also the story of the conservative legal movement and the story of our originalist Supreme Court. So it's funny thinking of it now, but 70 years ago or 100 years ago, the Supreme Court was not as politicized an institution as a confirmation process as it once was, as it is now. Just think about some of the justices who signed on to the Roe versus Wade decision. Justice Eisenhower has been reported as saying his two biggest mistakes when he was president are sitting on the Supreme Court. And I think he was referring to Earl Warren and William Brennan. Both of them incredibly activist judges, and both of them who were incredibly pro-abortion. Warren was off the court by the time Roe was decided, but Brennan was the author of Eisenstadt versus Baird, which is one of the decisions on which it was founded, which extended the privacy right to contraception to unmarried couples. The reasons he chose those people sound insane in today's world of recognizing how important these judicial confirmations are. Earl Warren had been governor of California, and he was a popular potential nominee, but he stepped back in favor of Eisenhower moving forward. And the story is that he did that and said, if I do this, I want to get the first available Supreme Court seat. And lo and behold, the Chief Justice retires and he's on the Supreme Court. And Eisenhower, of course, as a Republican president, you would think he would appoint, and he seemed to think Earl Warren was going to be a conservative judge. He actually was probably the most liberal Chief Justice in history and moved the court really dramatically into an era where binding themselves to the text and what the meaning was not their central focus. Bill Brennan was appointed because said he wanted to shore up support in the Northeast, and he was hoping to appoint a Catholic because they felt like they didn't have enough Catholics on the court. They hadn't had a Catholic justice in a while. So he's like, let's pick, and he wanted to reach across the aisle. So let's pick a Catholic Democrat from the Northeast. I mean, that's the level of kind of, this is a political chit to hand out, not, wait, what would his judicial philosophy be like? How does he look at the Constitution? What is his impact going to be on our law? And so, if you move forward to Richard Nixon, again, a Republican president, you would expect to be appointing conservative justices. He's the one who appointed Harry Blackmun, the author of Roe. So again, I think a lot of the presidents weren't thinking through, what is this person's actual judicial philosophy? How do they look at the law? That changed with Ronald Reagan, particularly because, and Molly Hemingway and I wrote a book on Justice Kavanaugh's confirmation, Justice on Trial. We got a chance to interview over 100 people on this. It was amazing to be able to interview someone like Ed Meese for this, because he was involved in Reagan's administration. He was the Attorney General and was deeply involved in the Supreme Court confirmations. He said the big change was that Ronald Reagan as governor had realized that when all of these initiatives he was trying to do as governor were getting slapped down by the courts, and the court was just reaching out and overturning things that they just disagreed with on policy matters. So he came into the White House recognizing the danger of having a court that wasn't tied to the law and that was reaching out and doing things that weren't in the law itself because they personally disagreed politically. That's never should be the role of a judge. And so he shifted his approach to looking at nominees. But once he did that, this started striking fear in the hearts of his opponents, because they said, wait a minute, with the Warren Court and to a large extent with the Burger Court, we've had the opportunity to affect policy in a way that we couldn't do legislatively. In 1973, if the federal government could never, apart from whether it was constitutionally possible, right, to pass a national law saying abortion must be legal in all 50 states, there absolutely would not have been the political will for that amongst the American people at the time. But all you have to get in the Supreme Court is 5 votes. And they recognized that. They knew that there's a real power to having a court that's willing to carry water for a certain political group. So the idea that that was going to change, and this new philosophy of originalism that was coming into vogue at the time, of recognizing really what some of the early justices recognized, which is that their job couldn't be just to reach into the ether and pull out what they think is good, but they have to reach back into the Constitution and pull out what those words meant. And it doesn't mean that these words are a blank slate, that a vague word or a purportedly vague word like justice or like liberty. I would say like privacy, but that word isn't in the Constitution. So that's the word they were trying to import meaning to in Roe. But those words aren't just blank slates for a justice to write his or her own favorite policies on, but that they have to reflect what the American people actually adopted when they ratified the Constitution or the relevant amendment. So this is coming into vogue. They realize the writing's on the wall. If there are justices who feel that bound to the actual text of the laws in the Constitution, we're not going to be able to accomplish all of these things that we used to be able to do, which was really kind of an end run around the regular political process. And so that triggered the major escalation of our Supreme Court confirmation fights. Robert Bork is someone who was a Yale law professor, just widely recognized as incredibly brilliant. In fact, some people have said that he and Justice Scalia were in the final decision-making process for Scalia's seat. And ultimately, there were a couple things. One, they wanted to appoint the first Irish-American or Italian-American justice, and that was going to be an exciting milestone. But also they thought, let's get Scalia in first, because Bork will be an easy person to confirm. He's clearly so outstanding. Everyone respects him. But Scalia is a little bit younger, like they're not going to necessarily have the same respect for him. Wow, definitely not what happened, right? Scalia was confirmed unanimously, and then Bork got borked. And that process, I think, also triggered a real change in our system. It was the moment when the Democrats kind of got together. They won the Senate in 1987. I think this is a really significant point. People talk about maybe the cultural changes that might have led to the possibility of blocking Bork, some of the missteps his campaign for his nomination might have meant, but I think the biggest difference is that the party controlling the Senate changed. And at that point, for the first time in American history, the Democrats sat down and said, wait a minute, it's always been understood that you just confirm, with the rare exception of someone who has a serious opposition, like say take Abe Fortas, who had a lot of ethical concerns when he was going in. Even if it's the opposite party, you confirm their nominees who are qualified and don't have ethical questions. But they said, wait a minute, we don't have to do that. We have the majority in the Senate, and we have the opportunity to block these nominees if we don't agree with them. And that, in fact, is an opportunity the Constitution does give to the Senate. I think it was one of the first times that the Senate really recognized how that their authority was not co-equal to the president, but was a serious counterweight. And we often talk about elections have consequences. Well, Senate elections also have consequences. And I think that's something that the American people are just starting to really recognize in terms of judicial nominations. The president gets to choose the nominee, but the Senate gets the up or down vote. Obviously, in Robert Bork's situation, he got the down vote. They rallied a huge campaign. For the first time, there were outside ads. It kind of took the White House completely by surprise. The idea that you would spend, hundreds of thousands of dollars on a TV ad with a famous, the voice of Atticus Finch is giving you these statements about Robert Bork, and the over-the-top rhetoric that was used suggesting that he would lead to, for example, women having back alley abortions, that lunch counters would be resegregated. All of these, this sky is falling type language, turned it into a political campaign rather than what it had been before, a relatively sleepy kind of incident. And going back to some of the previous nominees, I said Eisenhower's nominee, John Marshall Harlan, was the first nominee in American history to even answer questions at a confirmation hearing. So this confirmation hearing process even was relatively new. And the idea that you would then use that and weaponize the whole system to defeat a nominee was very shocking. The Reagan White House assumed that, well, it's kind of beneath this nominee to even respond to these things. And even Robert Bork's son, who was a journalist at the time, wanted to make a more full-throated response. And they said, no, we can't respond. That would be inappropriate. So his nomination went down in failure, and as a result, we ended up with, the next one actually was blocked as well. We ended up with Anthony Kennedy in that position. Ironically, someone who a lot of people thought was going to be a relatively pro-life justice. He's Catholic, his wife is pretty pro-life, I understand, and he talked about the sanctity of life before he came on the bench, but as we know, he later went on to uphold, in Planned Parenthood versus Casey, uphold and reimagine the whole system. Ever since those moments, and because of how outrageous an example of judicial activism Roe was, that decision became a touchstone for every confirmation battle ever since. And it's not because Roe versus Wade is the only activist decision that the court ever made, but it was important because it was one of the most clear examples, and an example that was so deeply felt by so many Americans, because simultaneously it was obviously wrong constitutionally. The abortion occurs nowhere in the Constitution. The closest argument to a constitutional mandate on abortion would be if you think that the 14th Amendment requires abortion to be illegal because it means depriving of unborn children of life without due process of law. So if the Constitution says anything, it's in the opposite direction, but it clearly doesn't say that abortion was legal. Clearly everyone who passed the 14th Amendment, not to mention all of the previous and subsequent amendments, thought that it was illegal in almost every state. I mean, so this is clearly not something that the Constitution requires, and yet the court invented it. And they invented it in a way that even at the time, legal commentators on the left were saying, this doesn't look like law. This looks like policy. This looks like you wanted to come to this conclusion, so you invented everything from the three-trimester framework, which if the word abortion is not in the Constitution, trimesters are definitely not in the Constitution, something that wasn't on anyone's radar, right? So it's clearly invented out of whole cloth. At the same time, it also touches on an issue that so many Americans, particularly religious Americans, realized was a great injustice that was so damaging to the unborn children, to the women who carry them and who are being brought into the process of death within their own bodies, to our whole society that then begins to treat people as disposable because they're not wanted, because they're inconvenient, because their father committed an act of violence against their mother, because you name it. And so there was a movement, and I think this annual recognition of that was really important in cementing that movement of people standing up and saying, no, we don't want to accept abortion. Women deserve better than this. Children deserve better than this. America deserves better than this. And people recognizing this is an illegitimate decision that has no basis in law. That wasn't the only decision, again, but I think it fueled a whole generation of people trying to get the courts back into alignment with our Constitution. And it fueled a huge opposition to that, because I think while there are a lot of decisions that people who are not originalists, who are on the left, might be worried about the court overturning on originalist grounds, the number one, the central focus was Roe. Like, if we have someone, the biggest problem I think in many people's minds about an originalist understanding of the Constitution is, yeah, but that would mean you'd have to overturn Roe versus Wade. And that's why in so many subsequent confirmation processes, that was a central question. Even, so the next justice that was nominated was David Souter. George Bush, the first Bush, nominated him. He was actually attacked as potentially being too pro-life by groups that thought he was going to vote to overturn Roe. Alas, not the case. Justice Thomas, whose confirmation process, even well before the Anita Hill fiasco, was dominated by these strange cryptic questions about natural law. And if any of you saw the great documentary on him, Created Equal, where it's in his first person, his words describing it, he talks about then Senator Biden's questions to him, which they play some of them, and they're just this kind of gobbledygook of academic weirdness on natural law. He's like, yeah, I have no idea what he was talking about. He was like, but we all knew what he meant. And what he meant was, are you going to appeal to a higher law that would require us to overturn Roe versus Wade? That's they weren't afraid of natural law because they had some philosophical position. They were afraid of it because they knew that abortion violates the natural law, and they did not want to see someone who would potentially appeal to that to overturn it. Now, it turns out they were wrong. Justice Thomas is an originalist, not someone who would overturn laws simply because he thinks they're unjust. But that was the hallmark of this process, and that was what drove some people, even before, again, Anita Hill, to say, we need to bork him. So that's what they attempted to do. Thankfully, that did not succeed, and we have Justice Thomas on the court, who long has been one of the most consistently and outspoken pro-life justices on the court. Justice Ginsburg, ironically, experienced pushback in her own confirmation process because of the idea that she would be not a fan of Roe. I mean, obviously, we think of her as being this icon of the feminist movement within law and really embracing all of those issues. But she had written, as a law professor, about how she thought that that Roe should not have been decided the way it was when it was. She talked about how dangerous and bad it was for the American system to have a decision that short-circuited all of the political debate that was going on at the time. And I think her view was it would have worked itself out politically and gone in the direction of being more pro-abortion. And when you short-circuited that, it ossified a movement, our movement, the pro-life movement, to fight back against that. And it gave them a clear focal point. And it also, because it took it out of the minds of the American people, they experienced that as, this is not just, this is not how our laws are supposed to be made. They're not supposed to be made by the majority vote of 9 unelected men and women in robes. It's supposed to be made by our American democratic process. So because she had criticized Roe and dared to even criticize it, even though she agreed with the ultimate outcome, that the timing of it, she was attacked on the left as being someone who might not be appropriate. Obviously, they got over it. She was confirmed, again, virtually unanimously, because that's how most nominations still were going. I think that a lot of the Republicans, even though they knew she would be liberal, said, well, we don't want to go down this road that has already been started with Bork and with Thomas. We want to go back to the good old days. It turns out there were no good old days to go back to. So she was confirmed virtually unanimously, so was Justice Breyer. And then we had another era of intense fights over even appellate nominees. And I think in the background, again, of all of this was Roe. We can't have people on the court who are going to potentially be those who would overturn Roe. This is the era in which we had Chief Justice Roberts and Justice Alito confirmed. It was an era where the filibuster was being used against judges. And it was an era where people all recognized we can't talk about Roe, but they all wanted to ask about Roe. So you had a lot of questions about stare decisis, which is one of those weird, legalese Latin terms that no one would know except for this case, right? The only reason anyone cares about stare decisis was because they wanted to make sure that Roe stayed in place. Because stare decisis means to let it stand. It means that a decision that's already been made by the court should stay. And that is a reasonable default presumption, because we don't want our law changing every 5 minutes. But every justice in the court, including all the liberal justices and the pro-Roe justices, recognizes that when a decision is egregiously wrong, sometimes we do need to overturn it. This is what happened in Plessy, when Plessy versus Ferguson, that said separate but equal was okay with the Constitution, despite, I think, pretty clear language to the contrary, requiring equal protection of the law. They overturned that in Brown versus Board and in a series of subsequent cases. And they would all agree that you have to be able to overturn that. They regularly argue that cases that they disagree with, from gun rights cases to various other cases, that those should be overturned, or that they're incorrectly decided. And yet they don't want this one case, this case that they think needs to be separate from everything else, to be overturned. And so that came up in all of those confirmation processes. And then fast forward to President Trump's presidency. Now, I think the reason he was elected in the first place was because of the importance of the courts to this issue, among others, but I think people were so motivated by this issue, because when Justice Scalia passed away at February 13th, 2016, the prospect of President Obama appointing his replacement, which really would have made the decision of Dobbs impossible. It would have cemented a majority in the court that would never have overturned Roe. That, I think, was that the possibility of someone making a different decision was what propelled the American people, despite many people's concerns about him, to nonetheless vote for him. And I have to say, well, on judges, he was absolutely the best president I can think of in terms of judicial appointments. So I'm very grateful that he recognized that moment was crucial to him even being president in the first place, and appointing. He would have said, I need to appoint pro-life justices. I don't think that's really actually the right way to think of it, because we don't agree that justices should simply substitute their own views for the views of the law. So if the Constitution did say, and Justice Scalia wrote about this a lot, if the Constitution did say that abortion had to be legal, and you were a justice who was morally opposed to that, you shouldn't substitute your views for that. And it's interesting, Amy Coney Barrett, when she was a law professor, wrote about this. She wrote about it in the context of the death penalty. But what do you do if you are a judge who, say, has a moral opposition to the death penalty, and you're sitting on cases where the death penalty is required to be applied? How do you do this? And her answer, which is the right answer, was first of all, you don't say, well, my conscience has to take second fiddle to the fact that I took this oath to uphold the law. We have the First Amendment for a reason. We never should put our conscience in the back seat and pretend that we can bifurcate who we are and just our religious beliefs from our public actions. She said, you also don't take the law and make it fit your conscience, because you have taken an oath to uphold the law. We are in a system where it's not judges who make the law, it's legislators. If you're a legislator, you absolutely should vote your conscience. If you're a judge, sometimes you can't if it actually violates the law, right? So she said in that case, the proper position is to simply recuse. You have to figure out first of all, figure out if they really are in conflict. Sometimes it's not a real conflict, and there are ways around that. But if there's a real conflict, you don't make your conscience violate your conscience, you don't violate the law, you recuse as a judge and have to say someone else steps in. So I think his formulation of we appoint pro-life judges is actually not quite right, but we need to appoint pro-Constitution judges. And thankfully, that's what happened. We had Justice Gorsuch, who himself, at the time, in retrospect, doesn't seem like a controversial nominee. At the time, he really was, despite his incredible record, his being respected by all these other judges. It was very difficult. He was filibustered by the Senate, and it was only because it was such an egregious moment where they were filibustering someone who's so clearly qualified and such a clearly excellent judge that we were able to get 51 votes. People like Susan Collins really felt strongly they didn't want to vote to get rid of the filibuster, but it was so egregious in this case. They said we can't be filibustering judges as qualified as Neil Gorsuch. Justice Kavanaugh, obviously, was a complete fiasco. When Molly and I went back to write the book, one of the things that was so striking for us was going back and looking at the time before the Blasey Ford allegations came out and how absurd it was even then. He was being called from the moment he was nominated complicit in evil. He was being attacked for everything from buying baseball tickets, to every aspect of his life. So it was being attacked, and he endured all sorts of allegations and historically long confirmation hearings, again, before Amy Coney Barrett's, or before Christine Blasey Ford's allegations. And then, of course, that came out. It was something that was held in the back pocket of Senator Feinstein until the last minute at those hearings, and then was released in a way that, there even just came out yesterday at Sundance Film Festival, another film about Justice Kavanaugh, which is bringing up, they're calling them new allegations, but they're not new allegations. They're allegations everyone knew about at the time that had been denied by the woman who's supposed to be involved in them. That's why they weren't followed up. So there were all these things that are saying, hey, how come they're not looking into this? They did look into it. They looked into it, and the woman said, no, nothing like that happened. But they've got this random guy who said, I can't even remember, he exposed himself to her at a party, some allegation like that. And as long as they've got some guy who's willing to say it, it doesn't matter how absurd it is on its face and how many people, including, again, the women involved, say that it didn't happen, they're gonna run with it, and they're not gonna let up. And I think a lot of that is an effort at intimidation. So these processes have been turned into a method for making sure there aren't judges who are gonna vote to overturn Roe. They thankfully were unable to succeed at that. And then making sure that those judges feel the pressure that if you step out of line, we can still come and attack you. Even though you have a life seat on the Supreme Court, we can still come after your reputation. We can still come after your family. We can make life dangerous for your children. I mean, it's really outrageous what has been happening. So that's a brief glimpse at the history of how did we get to this point where now we have an originalist majority. And the good news is we have judges who are willing to stand up to the historically high pressure to do what they know is right constitutionally. Going forward, I think the key is we need to stand behind them when they do so. We need to make sure it's clear that these efforts at intimidation of our justices are inappropriate. And then we need to take all the lessons we learned back to the states. All of these issues are being repeated now in states across the country. Currently, no states have the abortion written into their constitution, but there are a lot of states who have judges who have read it into their constitution. So I would say we need to go back to our home states, make sure we have judges who are faithful to the state constitutions, do what we can to make sure our own laws are faithful so that those judges have good material that they can come to moral conclusions, that we can help remove the scourge of abortion from America once and for all. So thank you, and I'm happy to take any questions with the time we have left.
Well done.
Thank you.
She brought that plane in on time. That was wonderful. Thank you. All right, so we have the microphones on the two sides here. So in order to make it easier for me to see potential questions, you can line up at the microphones to pose a question. And Sammy and I are talking on my Google Docs, so she is communicating with me on that. Now, while we're waiting for some questions to come in, I had a couple that I wanted to pose to you. First, recognizing that justices go through various judgeships in their career. Mm-hmm. I didn't know the right word to call it, but
that's correct.
What should lay people do to be aware of at the state level so that we can help get originalist type judges elected or confirmed or whatever our state, because each state has a different set of standards on how we handle judges. So what can the local person do to affect, because that's the feeder system, if you will.
Yes, absolutely. So I think, and she's right, every state has a different system. It ranges from elected with a partisan label, elected without a partisan label, appointed by the governor with confirmation, like at the federal level, appointed by the legislature. There's a whole lot of different, appointed by the one I think is actually most insidious, are a lot of states have what they call merit selection committees, which make it seem like it's a committee that's just picking people based on their GPA or something. And these committees get taken over by the local state bar in many cases, which are disproportionately on one side of a lot of these issues we care about, right? So it looks like this is a neutral committee doing it, but really it pushes the system consistently toward judges who are not going to be faithful to the Constitution and the rule of law. So find out first how your state's judges are selected and get involved in whatever way you can. If they are elected, if you can get involved in helping, it's very hard for judicial nominees to run because you can't make campaign promises, obviously. There's a lot of things you can't do because of judicial ethics, or to run for re-election even more so, because now you're a sitting judge, so there's a whole lot of ethical limits. So it's so important to have people on the outside who are able and willing to talk about what's at stake, what this person's judicial philosophy is really like. I think making it clear to your elected representatives, whether it's your governor, your state senators, your federal senator, and obviously at the presidential level, that judges are really important. That, I think, was a sea change in the 2016 election. Before that, we had a website that we put up called SCOTUS, Supreme Court of the United States 2016, because we wanted people to know, hey, there's going to be different people that have very different approaches to Supreme Court justices. That was before Justice Scalia passed away. And reporters didn't want to look at it. They're like, no one votes based on judges. Why would we even care? That message trickles down to the candidates, and they're like, that they think things like Eisenhower, well, this is a political shit for me to hand out, not this is the most significant decision I will make. And it clearly was the most significant decision President Trump made in his career. Many of his executive orders are out the window. Many of the laws he tried to advance are already being chipped away at or overturned. The justices are there for the next generation. So we need to make sure our elected officials know we take that seriously. We want judges who are going to be faithful.
Thanks, Carrie. Jill?
Carrie, can you speak to the Dobbs leak and then the apparent inability to find the leaker, and how will that impact these people on the court moving forward, not knowing?
Yeah. So that leak was such a shocking event. In this city where leaks from Congress are like a dime a dozen, leaks from the White House, no problem, it was unheard of for the Supreme Court to even leak the results of a case. In a few times in history, and I think Roe is actually one of them, that anything has been leaked, it's been like, hey, tomorrow we're gonna announce this case, and that alone would be a really shocking leak to know ahead of time what day it's coming out, and you know, this side is gonna win. That was a huge deal, and actually resulted in Warren Berger doing a big investigation because he was outraged that anyone would have leaked the results of a case. To leak an entire draft. I had friends who also had clerked at the Supreme Court who told me they did not believe it until the court actually confirmed it. Even though it was clearly, you read it, you're like, this reads just like a Supreme Court opinion. That would be a crazy deep fake. You know, who sits down and writes a 97-page hoax? But that was how unthinkable it was. Now, one of the biggest problems with this leak was that it made the unthinkable thinkable. And so now I fear that we're gonna have this going forward. And of course, for that span from May 2nd through June 24th, there was a price on all these justices' heads. And I think when I was talking about it publicly, I always worried about even mentioning that because I thought, oh my gosh, I don't wanna like give people ideas, but people obviously got the idea. They knew the only way to change the outcome of this case was to eliminate one of the justices in the majority. That would have been, I mean, can you imagine how horrible that would have been for our system? I think we can just thank God that the man who was in front of Justice Kavanaugh's house, it was like a combination of Justice Kavanaugh's guardian angel and that man's guardian angel who saved him from potentially committing murder, working together overtime, that he would have stopped and been stopped and kind of put the brakes on himself. But I think that is continuing to do great damage within the court. Not finding the leaker means that the honor system, which is really the fundamental way that the court was being protected there, because people have phones in their back pocket. We have a lot of people that have to have access to these opinions. There's no way you're gonna ever be able to lock it down with security measures alone. It has to be people's honor and professionalism and respect for the office and the oath that you take as an officer of the court that's gonna protect you. The idea that someone could violate all that and have no repercussions is just catastrophic for the trust that you can have within the court. I'm hoping and praying that there aren't future leaks, but I think this makes them very much more likely, and it means that the people within the court who need to be able to trust each other to work together now don't know who they can trust, and that's horrible for the system.
All right, we have a question over here. They're going to turn it on for you. Don't touch it. They'll go. Ready, Hank?
Yes. Thank you so much. I've learned a tremendous amount this morning. I'm so happy. And I'm curious about your personal journey. The age you appear to be, Roe would have been in force for probably most of your life, if not all. So you grew up in a world where that was just the way it was. And as a woman also going through schooling, the advanced schooling that you've had, did you refine your ideas about being pro-life, or were they challenged, or what was that environment like for you?
Carrie, before you answer, they want me to repeat the question.
Okay.
So basically, this question is asking a little bit about Carrie's background and how she, at such a young age, she has 6 children, has managed to become the expert you are. So tell us a little bit about yourself.
Yeah, so I was born post-Roe, but I was interested in this issue a little bit even in high school. I remember writing the first time I can remember thinking about it, and I don't know where I started hearing about it first, but I wrote a paper in high school about abortion and on the pro-life side. And I remember at the time, that was much more, it was a great victory, the pro-life movement. That was much more controversial, I think, when I was in high school in the 90s than it is now. I feel like nowadays, the discussion has shifted a lot more to LGBTQIA plus issues. And so to talk about those nowadays would have kind of the same valence, I think, as talking about abortion did now. So I think that is a great victory of the pro-life movement. I think it also comes from the experience, unfortunately, the experience of a lot of women realizing that the lie that they're being told that this is gonna be better for you and help you is really a lie, and the truth of the matter is it's not better for the babies, it's not better for the mothers, it's not better for the fathers, it's not better for it's not better for anyone. And so I think that helped. But so I was interested in this issue on the pro-life side in high school, but wasn't really active in it until I went to college, and that was where I started. I think that was the first time I attended the March for Life, and I think I had a lot of friends who were more involved in the movement, and that's where also I became Catholic, and that's a big faith community that's here at the March every year. But that's when I started really realizing, okay, I want to take some action on this. When I was in grad school, I went to grad school for linguistics before I went to law school. I volunteered with Project Rachel, doing ministry with women who were post-abortion. And wow, talking to the woman who had founded our local Project Rachel and hearing her stories of what this does to women, that really lit a fire under me, because you realize how this has this generational impact on her and on her future family. And it's so sad, the struggles that women go through post-abortion. And then when I went to law school, before that I was never really politically active in any way. I was a pre-med major, actually. So I was a biology major, and I was like, this politics stuff is not for me. Well, that was kind of when I became, got red-pilled on the fact that we really need to work on a lot of these issues in the political sphere. And I actually met my husband at the pro-life club. So I was an incoming first-year student. He was a third-year student and president of the pro-life group. And he saw this nice young first-year student, and he helped rig the election, so I won secretary for the group. So lo and behold, we had to spend a lot of time together, and we were kind of together in the trenches running the pro-life and religious liberty group at Harvard Law School. And that was, the rest of it is history, I guess. And so both of us then, I feel like this was an issue that brought us together, and it brought and continues to be a passion for both of us. We've gone in kind of different directions in the way that we have worked on it. I view myself as working first and foremost on just making sure we have faithful judges, but obviously having faithful judges in this area is a byproduct of that. And he has worked more directly in the pro-life movement himself, and right now is at the Heritage Foundation as head of their domestic policy issues, so abortion is a big part of his purview there.
Thank you, Carrie. All right, we have one more question over here.
I'll make it quick. Maybe it's a quick answer. You mentioned that no state had modified their constitution to put abortion wired in. I understand California is very, very close. I mean, it's gone to Newsom, from what I understand, for signature. So I assume that that's probably going to be very soon. It is. And then the second question is, what states is it moving in that direction very strongly? Because that may activate people to try and resist that. Over.
So again, let me just double check the question.
Okay.
The question is, basically is state constitutions to legalize abortion. What is the status on those, California being the first one, and does that actually work?
Yeah, unfortunately, I think right now where we are, California and I think Vermont had things on the ballot this last election, and this is, on one hand, at least their constitution is going to line up with what their court's already doing in the state. So, I guess it's not, the court won't be out of line anymore. But it's really concerning. I don't have in front of me the list of states where this is an issue. I think one thing that we saw that was discouraging in the last election is it's a challenging moment right now to try to pass initiatives in the opposite direction. One is that anytime you have a referendum or initiative, the no answer always is easier to get votes for than the yes. It's much harder to get people to vote yes on something, but I think also it's a time where there's so much money being poured into this. I mean, you look at Kansas and Michigan, they poured so much money in on the other side and so many lies about what the law actually even said. I mean, in Kansas, the initiative they were trying to pass simply was attempting to say, the state constitution doesn't speak to abortion. It was just trying to backstop against a court that had read it in. So it should have been the kind of thing that would be perfectly neutral, but it was demagogued to death, and actually then people ended up voting against it. Even pro-lifers were confused about the way the language was and might have voted against it, thinking that that was the pro-life response. So I think we have a lot of work to be done in that area, but right now I think the lowest hanging fruit is trying to activate against states if you see in your state that there is an initiative passing or a law passing, the biggest thing we have is to talk about the truth of what the law actually does, because so many times it's not clarified that, hey, this means you have an abortion all 9 months. Is that what you really want? This means you could that people could have an abortion because to discriminate against the disability of their child or the race of their child or the sex of their child. Is that what we want? And so I think talking about what actually is happening is our most powerful tool, because while the American people, if you look at polls, they're not 100% pro-life, but they're also not 100% pro-choice. And so making it clear, there's a lot of people in the middle who say, well, I'm not sure I would outlaw it, but I think there's a lot of areas where I wouldn't want to see abortion, so highlighting what's really happening is key.
Okay, last question over here.
Thank you for your talk, really enjoyed it. So unfortunately, I'm a little bit of a pessimist, and I can easily envision a world where the court continues to be increasingly politicized, and the moment that there's a textualist or living constitutionalist majority in the court, Roe is reinstituted. What are the risks of that? How do we prevent against the continued politicization of the court? And how do we prevent against complacency in a post-Roe world?
Yeah, 2 minutes.
Okay, 2 minutes.
Let me repeat, or do you want to repeat the
question? Go ahead,
question?
sure. Yeah, I mean, the court is in a position, if it switched, to put Roe back in place. They could do that any day. How can we prevent that? How can we prevent the continued politicization of the court? I think the problem is you're absolutely right. I think it's good that we're still here marching, partly because the battle is not only over in the states, but it's never permanently over in the US Supreme Court. All of this talk about stare decisis, about, gosh, once a decision has been made, we couldn't ever consider overturning it, could we? I would bet $1,000 that tomorrow, if they had a majority, every one of the justices who dissented in Dobbs would be happy to overturn it, just like they'd be happy to overturn all these other decisions that they disagree with from this court. So we can't just say, oh, well, Dobbs done. The job is never done. We still need to make sure we have justices who are going to be faithful to the law. We know that if we ever do get a Congress that is going to pass legislation that's protective of life, we need justices who are going to faithfully interpret that law, right? So we need to make sure that the court still, so that means keeping up the pressure when you have a president or a senator that you are voting for or speaking to, like, make sure they know this is an important issue for us. We need to continue to have these faithful justices. Honestly, I think the best way to get politics out of the process would be to convince everyone on both sides of the aisle that we just need to look at what the text of the law is. Because at the end of the day, that doesn't make you coming to conservative results. It just means, it only looks that way because liberal justices have been reading their views into the Constitution for so long. So moving back to zero, to center, looks conservative. But in reality, that means that that judges, if there's a very liberal law, if Congress passes a very liberal law on abortion, our justices are going to have to apply that even-handedly too. That's a very frustrating result, I'm sure, but that is the correct result legally and for the rule of law. So we need to make sure we're fighting this in the proper spheres and making sure we have justices and judges that know their role in the process.
Great. Carrie, you are awesome. Please give her a round of applause. She is...
Thanks so much.